on enforcement in the time of coronavirus, with John Drew from Cornwall Council as your speaker. My name is Dawn de Vries, and I'm the chair of the RTPI Southwest, and I'll be hosting today's event and coordinating the Q&A at the end of the presentation. In respect of housekeeping, you'll get the most out of the session. I'm just going to cover a quick point. The speaker's presentation will run for approximately 40 minutes and will come before the Q&A. So now the formalities are done, I'd like to introduce you to John Drew, who'll be presenting this event.
Thank you, Dawn. As Dawn said, my name's John Drew, and I've managed planning enforcement teams in Cornwall for about the last 14 years now, and then I had another 11 years before that working in development management teams, doing a full range of planning applications and different development management work. So I'm going to talk to you today a little bit about planning enforcement in the current strange times we've been in the last few months. And what I'm going to hopefully cover today is a quick recap of the planning enforcement regime. I don't intend to spend too long on that because I'm sure lots of you who work in this field will know about that. A bit about what planning harm is, and then moving on to the impact of COVID-19, including changes to some legislation guidance, including a quick sort of touch over the permitted development rights and the logistical challenge we've all been facing over the last few months. Then moving on to issuing enforcement notices, bearing in mind COVID-19 and any consequences that might have. And I'll put some case studies in at the end, not necessarily related to COVID, just some interesting stuff to have a look at to finish. So general principles of enforcement, we get one paragraph in the MPPF, paragraph 58. I won't read it there, but it's pretty self-explanatory that obviously it's there to maintain public confidence in the planning system. It's discretionary, and we should be proportionate in how we respond to breaches of planning control. And this is probably the key point, really. And obviously, if you work in planning enforcement, you'll get a lot of expectation from local councils, councillors, members of the public who probably don't always understand the constraints that we work under in planning enforcement. And these are probably sort of the key 4 points, really. It's not a system to punish people who carry out works without planning permission. It's there to prevent inappropriate development that wouldn't get planning permission. And I always find over the years I've been doing this, you talk to a councillor, why do you want to take action? Well, they haven't got permission for it. Well, that's not a reason to take action, generally speaking. You've got to identify what the planning issues are and what the harms cause. Again, people say it's illegal development. It's not illegal development. Breach of planning control is not an offence in the first instance. There's some criminal matters that come in later on, and obviously listed buildings adverts fall under a slightly different regime. But generally speaking, it is not illegal to go and build something without planning permission. A large percentage of breach of planning control have no harm taken against them because they cause no harm, and that the planning system is a permissive regime. And the way I always look at it is that sort of nationally we approve over 90% of planning applications. So that sort of demonstrates the permissive regime. And enforcement's no different, really, in that within planning application, you've got a set of plans and generally nothing built on the ground. Enforcement's the same in reverse, in that you might not have a set of plans in front of you, but you've got something that's built or being built on the ground, and you're making the same sorts of assessments considering development planning, other material considerations. And this is a quote that I quite often refer to when I'm dealing with difficult people, especially members and local councils, from Martin Goodall, a prominent planning solicitor. I think I took it from his blog, but it sets it out perfectly what the situation is, which is basically faced with unauthorised development. A local planning authority is in an initial quandary as to whether it's expedient to take enforcement action at all. As ministerial guidance makes clear, enforcement action should not be taken solely because the development was unauthorised. If the development does no harm, then there is no excuse for taking enforcement action, even if the developer refuses to regularise the position by applying for retrospective planning permission. And what I do when I'm dealing with sort of difficult people on this, I quote these sorts of quotes in responses to them to realise it's not just me saying it, in that there's, sort of try and give a realistic picture as to the constraints that we do work under in enforcement. I also quite often refer to the NPPG, National Planning Practice Guidance, and quote from that when I'm dealing with difficult people. And that talks about enforcement action being proportionate, and that you should usually avoid taking informal action where it's trivial or technical breaches of planning control that cause no material harm. or if the development is acceptable on its planning merits, an action would be taken solely to regularise it, and going back to they've done it without permission, they must be punished type of attitude. In their assessment, the local planning authority considered an application is the appropriate way forward to regularise the situation where conditions might be imposed. And that's quite useful, that particular one. I got involved with a case about 3 or 4 years ago where I got judicially reviewed on a decision I made not to take immediate enforcement action and instead invite a retrospective planning application for it. I was a pressure group that judicially reviewed that decision on the basis that they thought there was immediate harm and we should be taking immediate action and not giving the developer a chance to put a regularising application in. And at the High Court, the judge was pretty clear on this and said, that it's for the council to use their discretion on these matters. Unless there's exceptional circumstances, the courts will be slow to intervene on this. And if the council wants to give people a reasonable amount of time, and in our case, it was about 3 months because they had to comprise a big environmental statement to go with their application, that was perfectly fine, and they dismissed the JR. So that's, I think, specifically in the judgment quoted from the MPPG to that basis. So always a good one to use. What it also means is that again, the bottom line is if you're likely to grant planning permission for it, you're not going to be taking enforcement action in most cases. And we're moving on to planning harm. What is planning harm? Because again, if you deal with planning enforcement, you will know that people try and throw all sorts of things, and generally quite often with neighbours and disputes and what have you. But planning harm, and this is not an exhaustive list, but it's going to be things like increased risk of flooding, unacceptable design, harm to highway safety, loss of residential amenity, overlooking, that type of thing. Detrimental impact on general amenity when comparing with existing character, appearance and environmental quality of a place. Harm to heritage assets, harm to designated landscapes, AONBs, conservation areas, World Heritage Sites, and we certainly have plenty of those in Cornwall. And this is a really good example of planning harm. And this is the residential use of the land by stationing of a caravan in the countryside. In Cornwall, probably about 2/3 of our enforcement notices relate to this type of development, especially with the pressure on housing and such like. Lots of people put caravans on bits of land and go and live in them. And that's a clear example where there's planning harm, contrary to development plan policy, and we take enforcement action. Planning harm wouldn't normally be loss of value to a neighbouring property. Have that thrown at us quite a lot. A competition with another business. We're not there to limit competition necessarily. Loss of individual's view. It's always strange. People think they've got the right to look over other people's land that they don't own. They don't have in planning terms. Trespass onto someone else's land or boundary disputes, and breaches of covenants. They fall under the civil regime, and we can't go around enforcing breaches of covenants. So there we are, just a quick example. Neighbour disputes, they aren't a planning matter. So we've had sort of unprecedented times since March with COVID-19, and it looks like it's going to continue for quite some time yet. And the government have changed some stuff around to try and respond to that. I won't do a massive amount on this because I could probably spend a whole presentation just talking about PD rights, the changes, and what's going on, especially with the current court case challenging some of these new rights. But as it stands, as a very quick summary, the government basically urged councils to be more flexible on construction site working hours. So a lot of these are controlled by planning condition via construction management plans. And what the government have brought in is they've brought in a free fast-tracked deemed consent where we have 14 days as council to respond, no need to publicise. And what they're basically saying is that we really shouldn't be refusing applications to extend working hours until 9 o'clock Monday to Saturday without really good reasons. In some cases, we can go even further than that and allow 24-hour working. And that's all about allowing developers to operate with quite often reduced capacity to ensure social distancing rules and what have you on sites. And I have to say, the time this has been in hasn't caused us many issues today. I can only think of one site where it's been a bit of an issue. But again, flexibility is the key. Extending life of planning permissions, you need to be aware of that if you're an enforcement officer. Certain permissions and listed building consents that have lapsed or are due to lapse during 2020 will be extended automatically. Those lapsing from now till December automatically roll forward to April next year. Any from March until when the bill was enacted in the summer are subject to an additional environmental approval process. Such approval is free and must be given within 28 days, or if not, it gets considered to be granted deemed consent. And the Secretary of State reserves the rights to extend in the future. Another one that's quite topical where I am in this part of the world is pavement licenses. Lots of businesses, especially in the later summer months when things opened up a little bit more, cafes, restaurants, that sort of thing, because they're limited on reduction of space in their restaurants to allow social distancing, wish to put tables and chairs out on the highway to give them some additional capacity. And this new regime allows a license holder to place removable furniture on certain highways adjacent to their sites. And the new process is in place until September next year, and it's not necessarily planning of doing this, it's generally public health doing the licensing. But if a pavement license is granted, it in effect grants a deemed planning permission for it. And we've certainly taken a very pragmatic view in Cornwall from a planning enforcement point of view. We're certainly not looking to take enforcement action on these things unless there was really compelling reasons to do so. The building up, so additional stories permitted on blocks of flats under new permitted development rights. There's a prior notification process to go through, and there's various grounds there about retained light for neighbours and what have you that we have to consider as part of that. And existing flats must not be or form part of a listed building or scheduled monument on land within its curtilage, and they must not lie in a conservation area. They can be liable, could be liable for still, but not for Section 106. Temporary uses of land. A lot of uses have these 28-day permitted development allowances, and the government have extended that to 56 days up until the end of this year. Also, a new temporary right allows a local council to hold a market for an unlimited number of days without the requirement for planning permission from June until March next year. And it also allows the erection of movable structures such as stalls or awnings. And then from August, changes to several of the current prior approval procedures for the creation of dwellings to ensure the provision of adequate natural light to all habitable rooms is considered by councils. And then there's the Building Up 2, which was published out in July, which allows basically additional stories on houses, ability to demolish and rebuild vacant, redundant, purpose-built flats and commercial buildings that are rebuilt as homes. And there's also changes to the use classes in order to create flexible town centre uses. I've just touched upon here very quickly the amendments that have come out to the GPDO, which is about the prior approval process for Building 2 Up. And the flats one. And then some of the new use classes stuff, which is about a new use class E, subsumes previous classes, which was scheduled as class A1, A2, A3 and class B1. There's also a new use class F1 and F2, which subsumes some of the previous use classes, such as D1 and D2. Of course, what I would say about that is that there's currently a legal challenge going on at the moment regarding some of these permitted development rights, and I think they're in court as I record this presentation today, and there'll be a judgment coming out in due course. So it remains to be seen whether how that challenge goes and what the implications of that are. So we move on to breaks in continuity of use due to COVID-19 and how to consider. So you'll have a lot of developments that are stalled because of COVID-19. They've not been open or what have you. And how should we consider those potential breaks in use? Is it going to result in a use being lost? Well, it's the old planner's classic saying, a matter of fact and degree, whether it will. And some of these are some of the factors as to what you'd have to consider. So the character of the use which constitutes the breach of planning control, is it intermittent? The length of time there's any interruption, whether the land remains suitable available for the use during the period of interruption, such that the council could have enforced against it through the relevant period. Difficulties faced by the council in enforcing during the lockdown are not relevant. The fact that you might have some of your staff ill at home with COVID-19 is not necessarily going to be particularly relevant if you don't take any action. Fluctuations in intensity are not relevant unless they are as such as to change the character of the use and thereby amount to material change of use. And if the use ceases during the lockdown, the fact that it is for reasons outside the control of the applicant is unlikely to be relevant. And there's a case of Miles there where a planning inspector a few years ago took the view that a break on motocross use, where there was a break of 18 months because of the foot and mouth problem, that they in effect lost their use there for that. So that's something to bear in mind. Practical challenges for officers in the current times. Well, I suspect most of us will have been working from home. I've certainly not been into the office since March this year, I should say, before the first lockdown was announced. Site visits, have you been doing them? Are you doing them? Are you doing them in a limited capacity? How to factor in COVID-19 when considering the expediency of taking enforcement action and court delays. So I'm just going to touch on those now. So, as I said, I've been working from home for 6 months. It's likely to be at least another 6 months. And my suspicion is that in my own circumstances, I shall probably spend the majority of my time working from home permanently now. It's worked well as far as it can do. If it isn't broke, don't fix it, as they say. We use IT to stay in touch with colleagues. We use Microsoft Teams at my council, but people have got Skype, Zoom, or other alternative methods. And again, I found that worked really well when you have one-to-one conversations and team meetings, and it saved quite a lot of time on travel. In my authority, we can book, we've got some of our offices open, not all of them, because we're a big unitary authority, and you can book office space in a COVID secure way for occasional get-togethers with colleagues for collaborative working. I haven't felt the need to do that in my team yet, but I know colleagues have done it. So at my council, we didn't undertake any enforcement site visits in April and May. Same with planning applications, actually. We reintroduced visits in June in a limited capacity, but our starting point is, can we assess anything virtually using Google Earth, complainants, photos, that sort of thing. So if we can do it without visiting the site, we will do it, and that's still in place. We produced a guidance note for all officers, just to sort of do's and don'ts, which I'll talk about a bit more in a minute. And we have a dynamic risk assessment to assist officers when they go to a site as to whether they should proceed or not with a visit. And this is what some of the things we're doing in Cornwall on sort of general principles on visits. So if we do have to go somewhere, we confirm that no one present has been advised to self-isolate, has COVID-19 symptoms, or has recently returned from an overseas travel to an affected area before committing to the visit. If officers ever have to go as a pair, which occasionally happens, we don't travel to the site in the same car. We must go independently. We adhere to social distance measures at all times. Face masks are recommended, but we don't insist on that when you're doing open air stuff. And we provide our officers with anti-bac gel, and we just reinforce the general good hygiene measures when attending and leaving sites. What weight then do we give to COVID-19 when considering expediency? Well, what I've learned over the summer is it should not be a barrier to taking enforcement action, and we've served a number of enforcement notices over the summer months. Probably what you do need to factor in is slightly longer compliance periods to allow some of the uncertainty going on. So if we were to take action on an unauthorized residential use, we would generally not give less than 6 months. So if we were going to give 6 months, we might want to increase it to 9 months, and we've done that. And my authority have had a couple of Ground G enforcement appeal decisions recently, and inspectors have extended time periods for a couple of months. And this is one from a recent decision in Cornwall, which actually related not to a residential use, but it was basically doing some cosmetic changes to a building regarding cladding. We gave a month's compliance period. The appellant appealed on Ground G and asked for 6 months. And what the inspector said is that in ordinary circumstances, the council's period for compliance would be reasonable and proportionate to the works required to be undertaken. But he went on to say, in light of the government policy regarding COVID-19 and restricting social contact, I consider that this period needs to be extended. I shall therefore vary the period of notice for 2 months. So he gave an extra month, basically. It was a fairly simple thing to do. A month would have been fine under normal circumstances, but because of the current situation, he increased it by a month. He also noted that the current situation with the pandemic is fluid and it's unclear how long restrictions will last. So he just reiterated the fact that as councils, we have the powers under section 173A1B of the Town and Country Planning Act to extend any period for compliance at our discretion. So we do have discretion, and that doesn't prejudice our right to take any further action. Court delays, when you're doing prosecutions, some of you will probably be aware, be prepared for them. And the difficulty with things like that is managing expectation with angry complainants, local councillors, local councils. And I think you just have to be honest about it. Magistrates Court, we're not finding it too bad at the moment. We've had a couple of things that were due in court in sort of April with magistrates that got deferred till July, but we got results there at those where people pled guilty. So not too much of a delay, magistrates. Crown Court's a different matter. I had a trial set for July this year for a Crown Court trial where someone had pled not guilty. That's been adjourned now until 2021, and we're talking it might be as late as the spring of 2021. So that's 9-10 months. So I've got some unhappy people about that, but it's out of our hands. And to be fair, when you explain the circumstances, most people sort of understand we are living in, and I hate to use the word, but it is unprecedented times. Most people do understand there's sometimes more pressing matters to worry about than planning enforcement cases going to court. So my final sort of third of the presentation, I just thought, having covered some of the COVID stuff, just some general case studies really, and a little bit about planning conditions just for out of interest and some learning points from them. So how long can an enforcement case take? Well, it can range anywhere between a few weeks if someone is prepared to put something right quite quickly, to 2 to 3 years and longer than that, depending on whether the landowner decides to challenge the councils through the appeal process in courts. I've had some appeal decisions through where we served enforcement notices 18 months ago and we've just got the appeal decisions through. So that's out of our hands, clearly. So it is a long process. And again, it's all about managing expectation in that regard. My next slide is basically a real life enforcement case in Cornwall, which I know about because I signed the enforcement notice. And it just gives you a sort of an indication of timeline. So this was a new house built without planning permission. You see the big arrow there, that particular property there. Fairly isolated rural location, as you can see. And we took enforcement action because it was the dwelling adversely affecting the character of the countryside in an unsustainable rural location, and the site was in a flood zone. Now, this photo was particularly useful at the appeal when we had to demonstrate the flooding issue there, because you can clearly see the road has flooded right by the site, and sort of helped disprove the appellant's assertion that it wasn't a big problem. So this particular one, the enforcement notice, we served it in September 2016, requiring the house to be demolished. The landowner lodged an appeal, and PINS determined it, and we got a decision with the appeal dismissed and the notice upheld in May 2017. It's not too bad, sort of 8-9 months from when we served the notice. Of course, that gave the owner a decent compliance period until February 18. So I suppose at that point you're looking at over a year and a half after we served the notice from a compliance date, and the owner didn't comply. Not surprising, they spent £80,000 building a house, they didn't want to knock it down. So what did we do first of all? Well, obviously we've got the 3 options of prosecution, injunction, direct action. If I'm honest, we generally look at a prosecution as a first resort, as a lever, not because we expect a high penalty out of it, but it's normally a way in to try and get people to comply. We started the prosecution proceedings, and the owner pled guilty to not complying. And actually I got a £5,000 fine, and I've been involved personally with about 40 odd prosecutions over the years. And that's the best fine I've ever had. If I say that most of the time it's conditional discharge, 300 quid, 400 quid, 500 quid fines, this was actually quite a good result, and we got costs back of £1,300 as well. And again, what I just said, that was the lever in, and we basically made clear to the appellant we wouldn't leave it lie at that, and we would consider further action, which could include an injunction or direct action. And in October 2018, they demolished it. So this wasn't an unduly long process, but it still took 2 years and a month from when we served the notice to the dwelling being demolished. And we made the national press with that one. That was taken from the Sun newspaper online, where headline was "Woman forced to demolish new £150,000 home as it was 1 metre too high." That's not the reason why we took enforcement action, because it was 1 metre too high. It didn't have any planning permission, and I set out the reasons why. But that's the press for you. They don't always get the right end of the stick, but we did make the national press on that one. And there's a photograph showing the dwelling gone. Doing especially criminal stuff, you get all sorts of arguments people make in defending unauthorised development. And this is I took from the press in Wales, and this was a shed where they put some wheels onto it. And what happened was that they built the shed without planning permission. The council served an enforcement notice. The owner added the wheels after the notice was served, arguing it was no longer a building and mobile. The council argued it was still a building and prosecuted the owner successfully in the magistrates' court for not complying with the notice, and they got a £700 fine. However, probably quite unusually, the defendant took the matter to the Court of Appeal, arguing a council officer advised him that if wheels were added, permission would not be required, and that the prosecution was an abusive process. Because it's a criminal matter and you sort of have a high burden of proof beyond reasonable doubt, the defendant's case was basically the officer told me it would be okay, and therefore it's an abusive process to bring me to court. And the Court of Appeal agreed with the defendant that he relied in good faith on the advice of the council officer by adding the wheels, even though it was the wrong advice, because I don't think the best will in world you can say that made it a chattel rather than a building, and the reality is they weren't ever going to move it around the site anyway, and it would bring the administration of justice into disrepute to uphold the conviction, and they quashed it basically, and the council will have to pay defendants costs in excess of £10,000. And this is a genuine quote. The defendant stated he was really pleased that the case just rolled along. That was a genuine quote in the press. Well, I assume it was a genuine quote. But that's a good lesson that as an officers and councillors, you don't want to give misleading verbal advice to persons. And although the council decision to take enforcement action was sound, the prosecution was scuppered by those advice. I'm guessing the notice still basically remains, and the council have to consider what they want to do about that now. But because it's a criminal matter, there's a different standard of proof. And you probably know this, but it's best never to give advice off the cuff like that verbally. Always make sure there's a written record of it, so you don't get into an argument over he said, she said. Planning conditions. Most of you will have had issues with planning conditions over the years, and how important it is to get it right. So there's 6 tests for imposing conditions. They have to be necessary, relevant to planning and to the development to be permitted, enforceable, precise, and reasonable in all other respects. And I've probably lost counts over the amount of times over years we've had difficulty enforcing conditions that have perhaps not been drafted as well as they could have been. And this is taken from the MPPG again. What probably the bottom line is, authorities should ask themselves whether planning permission would have been refused if that condition were not to be imposed. And I was guilty as anything when I did planning apps 25 years ago. I had my list of standard conditions and I didn't put them on. I just put them on. I didn't necessarily think always as to why I was doing it. And if I didn't put the condition on, would it have made the development unacceptable? And the answer is probably not, in that I'd probably put a lot more on than I needed to do. Ability to enforce, it shouldn't be imposed if you can't enforce it. And again, think about it logically as to, can you enforce a condition? If you put a condition on limiting occupancy of number of people in a building, realistically, how are you ever going to get that information to? You're not going to put someone outside for 24 hours counting people in, counting people out. So you need to think about things like that. Don't put conditions on to satisfy objectors. I've done that in the past. It's come back to bite me. Carefully check conditions suggested by consultees. Ultimately, it is the council's case, and you've got to determine whether the condition is necessary and reasonable. And there we are. That's what I just talked about as regards to sort of persons' residence in a block of flats. It'd be impractical to monitor such a thing. So again, some genuine examples of stuff that I've come across over the years. This is a wind turbine condition. We obviously don't get so many of those now, although that might change in the future. And obviously, this particular case was an issue of noise coming from the turbine. And we imposed a planning condition that didn't really offer a lot of protection. I'll show you what the condition says. So the first part, Fair enough. Noise emissions from the approved wind turbine should not exceed the following levels. And it talks about a decibel limit. It's a good thing. The second part of the condition talked about, and that was the first part of the condition is basically related to the applicant's own property. The second part of the condition basically puts a decibel limit at wind speeds up to and including 12 meters per second at 10 meters height, where the occupant of the wind turbine has no financial interest. And that's clearly there's no occupant of the wind turbine. It was meant to do occupants of other properties in the locality. But we know what the spirit of the condition was meant to say, but you can't enforce on the spirit of the condition. You have to enforce on the actual wording of the condition. So but all the protection those local residents would have had has gone. So again, it's imperative to get the wording of the condition right. It's clear what it's meant to say, but the fact is it didn't say it. Although it's a genuine mistake, which anyone can make, we've all done it, you can't enforce the condition. There we are, living in a wind turbine, what we envisaged. Other genuine conditions that are enforceable, again, these are all genuine ones that I've come across over the years. Noise from the operations within the application site shall not exceed 40 decibels as measured at the boundaries of Cornish Concrete Products Limited between the hours of 7 in the morning and 7 in the evening, Mondays to Saturdays, and no work on Sundays and bank holidays. On the face of it, that looks okay. Then you realise, what about 7 at night till 7 in the morning? There's no limit at all. So you're limited to 40 decibels during the day, but at night you can make as much noise as you want as regards to the planning. I mean, obviously there's the statutory noise nuisance regime that might capture statutory nuisance on noise, but and clearly it's probably more important to have restrictions during the night time than there is during the daytime. So again, an honest mistake, but one that has consequences. Other ones that are quite interesting. Prior to the commencement of the development, samples of all external facing and roof material should be submitted. That's fine, but that's as fine as far as it goes. But what it doesn't say is that you should then get them approved and then do the work. So all they've literally got to do is submit the details to the council and they've complied with the condition. Nothing about them actually then doing it on site. And this is one of my favourite ones. Within 3 months of the date of this permission, the permanent removal from the site of the fencing, as agreed out on site, to the western end along the northern boundary in the front garden and timber double garage shall occur along with the resiting of the timber shed to the side of the bungalow in either the rear garden of the property or off the site. Personally, I can't make head nor tail of that as what is trying to achieve. And the classic one is what was agreed on site. Who knows? Totally unenforceable. I mentioned this one because sharks have appeared again recently in the planning world in news, and it's the old Headington shark from the 1980s in Oxford. And I picked up on it really because of the recent court case in Hackney, which I'll move on to, about sharks. And Bill Heen, the guy who installed this back in the 80s, died last year. And I saw his obituary in the national press and it jogged my memory. And the appeal decision is one of the most entertaining appeal decisions I've seen. And the summary at the end basically says is, the council is understandably concerned about precedent here. The first concern is simple proliferation with sharks and heaven knows what crashing through roofs all over the city. The fear is exaggerated in the 5 years since the shark was erected, no other examples have occurred. Only very recently there's been a proposal for twin baby sharks in the Ilfley Road, but any system of control must make some small place for the dynamic, the unexpected and downright quirky, and allowed the shark to remain. So it finally, he won his battle, Mr. Heen, against the local council. And I mention it because sharks have returned to Hoxton Docks in Hackney in 2020. 5 are planned, they've put 4 in to date. And these were designed by an architect called Jamie Shorten. And they're singing sharks that have been selected as the winner of the Architecture Foundation's anti-pavilion contest. They were installed in Hoxton Docks Canal, and they can have audio equipment to give lectures and what have you. And it was inspired by the Headington shark. The architect made clear about that, which is where it links in with what I've just talked about. And the aim behind this was to, the brief was to focus on the tensions between the authoritarian governance of the built environment and the ascetic libertarianism. However, the Hackney Council won an interim injunction preventing the displays of this, and the court hearing, I think, is going on at the moment as I'm probably speaking to you. I don't know the outcome of that yet, but watch this space on that. And then finally, to finish, another sort of case that's just a bit interesting, really, again, that's made the national press in the last couple of years. And again, it's just amazing what some people will try and do without permission. And this is an outbuilding built in the rear garden of a property in the Forest of Dean, which is in a back garden, which is 10,000 square feet. There you can see how on earth they thought that didn't require permission. To this day, I'll never know. But they built it, and it contained a home cinema, casino and bar, a 10-pin bowling alley, a squash court, gym. And as I said, the landowner incorrectly thought he didn't need permission. The council served an enforcement notice in 2014 with a 2-year compliance period, which is quite generous, but obviously quite a lot of work to do to dismantle that. They lost an appeal and didn't comply. The council sought an injunction, which was issued in November 2018, giving the landowner a further 18 months to comply with the notice. And of course, a breach of conjunction is a contempt of court and could lead to a custodial sentence, which is sort of the ultimate deterrent, really, I suppose. The landowner basically said that it will cost him 720 grand to demolish it after building it, and he's ordered to pay 30,000 costs to the council. And he's basically said it will result in the collapse of his accountancy business, having to lay off all of his staff. As far as I'm aware, the injunction should have been complied by May this year, but it hasn't been complied with date. Probably, obviously, the COVID situation now has probably put some spanners into this work, and might well be a delay in getting it back to court. Possibly, I don't know, 'cause I've not spoken to the council. But watch this space to what happens with that, and it's ultimately going to be a very expensive lesson to learn for the landowner. So that's it from me as regards to the presentation. Thank you for viewing it, and I will hand back to Dawn for some final questions.
Thank you very much, John, for the presentation and the really interesting case studies that you picked up on. We've just got a couple of questions that have been sent in ahead of the presentation. So if you can just give your comments to this.
Of course.
So how are local planning authorities carrying out PACE interviews currently? And if they cannot or have limit to face-to-face meetings, are there any provisions within the legislation that allow for this to be done remotely?
Sure. Well, I can tell you what my team have done, and actually we've done it well before COVID-19 as well. In that, clearly there's going to be an issue getting people into a small room with a tape machine and interviewing them in the sort of more traditional way. But what I've done for a number of years now is doing PACE interviews by letter. So you basically write a letter, you include the caution on it at the beginning. You don't have to say anything, but anything you do say, and you ask your questions in writing. We normally give 21 days to respond. Obviously, they don't have to respond because they're under no obligation to comment. And we've done that, and I've been doing that for a number of years now. And I've done about 30 prosecutions where we've done it that way. And when I first started doing it, obviously the lawyers were pretty much, no, you shouldn't be doing that. It's not going to work. It's going to be really difficult. But I can honestly say in 30 odd prosecutions, it's never been an issue at court. And I think bar one of those cases, we got convictions every time. So my advice is consider doing it by letter in the short term while we've got the current. I mean, if there's a way you can do it face to face, still absolutely fine. But your lawyers might have some resistance to it. But I can say from personal experience over 10 years, it's never been an issue to do it by letter. It's never been raised. So that's the way I would do it personally.
Certainly sounds like a plan at the moment.
Yep.
Have you got any thoughts as to why housing developers refuse to adhere to planning conditions set out as part of the permission?
Well, the key thing is they don't all not comply, but I accept there's a problem there. There are some good developers out there. The motives behind them can vary, can it? I mean, it can be inadvertent errors that the contractors just don't necessarily get briefed as well as they should be doing. It can be things change as you're doing the development, things change on site, and you get to the other extreme where it's just willfully disregard by the developers. So there's a variety of reasons, to be honest with you. There's no clear answers to why your developer does it. Say inadvertent right through to willful disregard. Who knows? In simple terms.
Thank you. So just another question, how would district councils enforce on planning breaches, or how could we stop breaches happening in the future?
Okay, well, especially when you go back to you've got your options of breach of condition notices, enforcement notices. I don't need to go through the technical details of doing that. And you've obviously got a combination negotiation as well before you get to that point. On the big house developers, in an ideal world, you do proactive monitoring of conditions, but I accept the fact most of us don't have the resources to do that. So what we try and do is explain the benefits of compliance with developers. Obviously, they want to go and sell these properties, and if there's issues with things not being complied with, that's going to hold up their sales and their sort of cash flow and what have you. So we try and do the benefit. And then the other thing that what we do in Cornwall is that we do publicise good outcomes. So every time I do a prosecution in court, gets a press release sent out for it, just to try and get the message out there that we do enforce and this is what can happen. And the press generally pick up on that sort of stuff. So it's a combination of negotiation, enforcement where you have to, but talking and trying to get some good relationships with developers, so they know what's expected, sell the benefits of that to them from their point of view, and publicity. So a combination of all of them, really.
Brilliant, thank you. And the final question I've got, are construction methods statements taken seriously enough? And during the pandemic, it's interesting to touch on PCNs, which local authority is relying heavily on at this time to gather information if there's any common pitfalls.
Okay, well, with construction method statements, they are important, but what I will say is clearly things have changed over the last 6 months, and the government's made it quite clear we need to be a bit pragmatic and flexible as councils with this stuff, especially around the construction hours, for argument's sake. Lots of construction method statements will have hours of operation on sites, and clearly we need to be flexible in considering those. So it's a case by case sort of assessment each time, but clearly on things like hours of operation, we need to be more flexible. Clearly, if there's other parts of it that are fundamentally causing an issue, you've still got the option to enforce if you feel it's appropriate. Planning contravention notices, just general tips really. Good practice to ask clear, concise questions relating to breaches of planning control. Always worth putting a question on and giving the recipient an opportunity to suggest how they might resolve it themselves, see what they think about that. And probably the basic point is don't ask questions unrelated to the breach, which is commonly known as phishing. You shouldn't be doing that. And make it clear that the recipient can talk to you about it and sort of have a discussion away from that as well. So that's the general good principles of planning contravention notices.
Thank you. So thank you for your presentation. I'd just like to thank everyone for taking the time to log in today. Please feel free to keep an eye on the RTPI website for any more virtual opportunities. So in the meantime, be brave, be bold, and be brilliant. Thank you and goodbye.